And welcome to tonight's Fulbright Forum. My name is Randy Tarnowski, and I'm the Executive Assistant at the Korean American Educational Commission. Thank you for all coming tonight. For ETAs, thank you for spending your last Friday before school starts here supporting your fellow grantee. Tonight's presentation will last for 50 minutes. We ask that you hold questions until the end, during which time we'll open the floor for a brief Q&A. Afterwards, we invite you to stay and enjoy light refreshments prepared by the KAC staff. There's more than the jelly beans and Oreos in the back, I promise. So tonight, I'm pleased to introduce junior researcher Ann Park. Ann holds a BA from Wesleyan University and a JD from Loyola University Chicago School of Law. Here, in addition to receiving a certificate in child and family law, Ann studied as a Civitas Child Law Fellow, an award given to exceptional students who seek to advocate for children in their legal careers. It is clear that Ann's passion for advocacy has extended into her Fulbright research. Since beginning her Fulbright grant in August, Ann has worked with judges, lawmakers, and faculty at Sogang University School of Law to study South Korea's child welfare system. She argues that this system is currently undergoing a period of transition, with increasing public awareness due to a series of highly publicized cases in recent years. So tonight, she will highlight a small portion of her research for us, exploring the Act on Special Cases Concerning the Punishment, etc. of Crimes of Child Abuse, which was enacted on January 28, 2014, and became effective on September 29, 2014. I believe that Ann's research, by shedding light on this new law, will continue a critical conversation surrounding Korea's child welfare system. And so with this, please join me in welcoming Ann Park to the front. Thank you.
Thank you, Randy, for the wonderful introduction. That sounded like my entire presentation. Good evening, everyone. Thank you so much for coming. I know that some of you have traveled from far away, and I am very, very pleased to talk about my Fulbright research on South Korea's child protection law and system, especially for abused and neglected children. Before really starting, I'd like to share my personal background a little bit, which pushed me into this area of law. So I spent 15 years growing up in South Korea and attended Korea's public elementary, middle, and high school until I turned 17. So as I was studying child law in the United States, I always reflected upon my memories of my childhood spent in Korea, associated with my family, relatives, friends, and teachers that I always spent time with. And I had this desire to study Korea's child welfare system through Fulbright project, and luckily I got this wonderful opportunity. So after submitting my Fulbright application in fall 2013, I became aware that huge transition was happening in the Korean child welfare system. There were two major abuse cases happen, one in August and the second one in October. And those major abuse cases that happened in Ulju, Chilgok and Ulju led to a huge movement among law scholars and child rights activists and politicians to create the new law. So I am very fortunate to have this, to work on this timely and very significant project. So why is this study significant? First, child abuse has severe and long-lasting physical, psychological, and developmental effects on victims. And child abuse is a cycle that repeats and continues. And child abuse, especially in Korean society, child abuse is often invisible and untold because rearing, educating, disciplining a child is considered as private family business. So it has been largely ignored in Korean society. Also, there is lack of understanding about the system or the law that protects children from abuse or neglect. So perpetrators are neither informed nor afraid of the legal consequences. And stakeholders, including lawmakers and politicians, teachers, and all the frontline workers, including police officers and prosecutors, they don't really understand what's going on. So let's get started. These are the 4 main research questions that my research aims to answer throughout the presentation. First, what are the child abuse and neglect situations like in South Korea? And the causes for child abuse and neglect in South Korea. And the most important part of this presentation, which is child protection law and system for abused and neglected children. And I'd like to conclude, it's going to be my concluding point that I want to answer, and what can be done to further improve the law and system. But just let me give you a little caveat. I'm still working on this part for the rest of my research period, so I don't have the complete set of recommendations. So later on, if you can give me your ideas, thoughts, or insights, then that will be highly appreciated. So in order to answer these questions, I am applying this method: legal analysis of current and previous legislation. And I also interviewed actually many professionals in different capacities, including law professors, who actually drafted the new legislation. And then the head of the National Child Protection Agency, who oversees and supervises the Child Protection Agency employees, who are the frontline workers at the scene of abuse. And then the family court judge, who is pretty new to a lot of duties that now he has because of the new law that was implemented last year. And then I also reviewed written articles and reports. So this presentation is organized as shown. In the next slides, I will go over the definition of some key terms, and also I will discuss some statistics and facts on child abuse in South Korea. And I'll highlight some factors contributing to child abuse. And then after that, I'm going to discuss the law. So history of the Child Welfare Act, which is old law, will lead to the overview of the new law. And concluding portion of the presentation will be assessment of the new law and system and my incomplete set of recommendations. And then if you have any questions during the presentations, please feel free to raise your hand, because there's some ideas and key terms that you have to understand in order to understand the presentation. So yes, if you have any questions, please let me know. So let's review some key terms. I'm not discussing the law yet, but wanted to go over these key terms early in the stage because these terms will keep appearing throughout the presentation. So according to the law, the Child Welfare Act, child by definition is a person below the age of 18. And this definition is identical to the definition in the United Nations Convention on the Rights of the Child. And the definition of child abuse is to harm and sexual violence or cruel acts that are likely to impede normal growth of a child by adults, including the protector, and abandonment and non-intervention committed by a protector. According to this definition, abuse is grouped into 4 types: physical abuse, mental abuse, sexual abuse, and neglect. And let's go over the definition of protector. Protector is the main, actually the role of protector is highly emphasized in the definition of child abuse. A protector is a person in parental power, a guardian, a person who protects, rears, and educates a child, or who is liable to do so, or a person who actually protects and supervises a child due to the relations of business or employment, etc. Please note that the definition of child abuse heavily emphasizes protector, the role of protector, and the scope of my presentation is also limited. Sorry. limited to the case where these protectors are perpetrators. So let's look at some pictures, actually statistics. This graph shows the total number of reported cases that suspect child abuse. The blue line shows that. And then the purple line shows the number of the confirmed child abuse cases. So in 2014, there was total number of 17,789 reported cases that suspected child abuse, and 9,823 cases that were confirmed to be child abuse cases. And as you can see, since 2001, the number has been constantly increasing, although there was a slight drop in 2010 and 11. Experts view that this increase can be attributed to the increased public awareness about child abuse, especially in 2013. Like I said previously, there were 2 major child abuse incidents, and then that grabbed public attention, and that led to more reporting of child abuse cases. So, who are these perpetrators? Well, there are so many people who can be perpetrators, and as you can see, parents account for 82% of all perpetrators, which is an overwhelming majority. The relatives and welfare institution employees, and then daycare employees follow next, but each of them does not even exceed 1-digit figure. Despite the growing concerns about abuse in daycare, we all know about these daycare abuse incidents that happened this year, it is unlikely that they will be any close to what parents account for. And this graph shows the occurrence of child abuse. So 39% of child victims reported that they experience abuse every day, which is bad. According to this graph, more than 65% of the victims suffer abuse at least once a week. This shows that children are exposed to frequent and repetitive abuse. Then why is child abuse happening in South Korea? What is it that contributes and what is it that causes child abuse? Domestic violence can be one thing, and lack of parenting skills, and unemployment and poverty, which easily leads to neglect of child, and alcohol and drugs, and then which can cause problems of parents' mental and behavioral health, and economic and social stress that can also lead to some violent behaviors, and lack of understanding of the law. And lastly, traditional Confucian teachings that allow corporal punishment. Most of these factors are pretty common in other cultures, but the last factor is pretty specific to the Korean culture. The traditional Confucian teachings allow corporal punishment in school and home, describing it as a form of disciplinary measures that is rooted in love. And there is even a term called 사랑의 매, which can be translated to rod of love. And there has been confusion about how to actually separate the disciplinary act from corporal punishment and corporal punishment from abuse. The line is really blurry. To what extent parents' discipline act can be allowed and or permitted. So there has been a lot of debate going on in Korea whether it is necessary to abolish corporal punishments overall. And this slide portrays power dynamics between child, parent, and state. State, I mean government. I made a brief comparison chart of Korea and the United States. So let's look at the US side. In the United States, the state government plays the role of parens patriae, which means parent of his or her country. According to the doctrine of parens patriae, my Latin is not that great, the state acts guardian for those who are unable to care for themselves, such as children or disabled individuals. And the state has an obligation to ensure the safety and well-being of children. There is an argument that challenges the whole idea of parens patriae, saying that the family privacy and freedom to make decisions on behalf of child should be respected, and it cannot exceed, and then the government power cannot exceed the family privacy. However, in the proper exercise of its power as parens patriae, the government can require parents to provide proper food, clothing, shelter, and medical care to their children. And parental failure in that regard can lead to the removal of children from their parents' care. And in the worst case, it can also lead to the termination of parental rights. On the other hand, in South Korea, parental rights are so strong that the government traditionally avoided intervening in family matters. One of the family law professors that I interviewed summed the whole idea or tradition into one sentence: law cannot jump over the family fence. There is recognition that active government involvement is necessary in Korea, and Korea hasn't actually taken a step toward that. But it is important to understand that the underlying idea that has shaped the existing law and system. But as a result, termination of parental rights are pretty rare in Korea at the end of the child protection proceedings. On the other hand, in the US, of course, termination of parental rights are not the best solution. It's actually not preferred, but it is actually used as a last resort and happens. And this is another comparison chart between the United States and Korea. I'm sure some of you are familiar with the United States, the US child protection system. So the main child protection institution in the United States, generally named like State Department of Children and Family Services, or in this kind. For Korea, there is one central child protection agency, which is called National Child Protection Agency, and there are 51 local child protection agencies in different regions. It is noteworthy that in the US, the child protection institution is government, whereas in Korea, the child protection agency is a civil organization. And then let's look at the level of court involvement. In the US, child protection proceeding is led by court. The social worker submits a petition alleging that the child is abused or neglected, etc. And then court make decisions. And from there on, the court keeps on making decisions and issues orders for the parents to change behavior and environment. Whereas in Korea, judges make decisions after police and prosecutors referrals. So even before the case gets to the court, a lot of decisions have been made by police and prosecutors. And then there is societal difference about corporal punishment. In the US, corporal punishment was abolished as early as in 1867, whereas in Korea, corporal punishment was abolished in schools in Seoul and Gyeonggi area, but it is still allowed in home. And objective of child protection. The US explicitly says that it is to reunify families and protect families and rehabilitate families. Whereas in Korea, in the current state, it seems like criminal proceeding, which I'll explain further later during this presentation. So let's look at the Child Welfare Act. The Child Welfare Act is the very first legislation addressing children's welfare, which was implemented in 1961. as it wasn't long after the Korean War, the main purpose of the law was to rescue war orphans. And since then, there have been 27 amendments until 2014. But the 2000 amendment is considered a pivotal development because in the 2000 amendment, child abuse was defined for the very first time and actual government interventions began. Also, the National Child Protection Agency and the local child protection agencies were established. Yet, it was commonly agreed that the law was not comprehensive enough to overcome the underlying obstacles to intervention of child abuse cases. So previously I mentioned that there were two major child abuse cases happening in 2013, and I'm going to talk about one of those cases, the case that happened in Chilguk in August 2013. So stepmother abused her two stepdaughters. One was 11 years old and one was 9 years old. And after like a long extended abuse by the stepmother, the younger daughter died. And in courtroom, the old daughter falsely testified in court that she killed her little sister, and it was not her stepmother who killed the sister. And it was later found that the older daughter was coerced into testifying falsely. And during 450 days of the visible abuse history, there were a total 37 witnesses, and several reports were made, but no proper intervention took place. The children were never removed from home, and no charge was made against the parents. As a result of this case, stepmother was sentenced to 10 years in prison. So this case actually shows the holes in the system that failed to intervene when the child was supposed to be removed from the danger, and the charge was supposed to make against the parents. So there was a big movement among different professionals, law professors, and legislators, and including politicians, and child rights activists, and child protection agency. They all got together and discussing the deficiencies in the existing child protection system, and the recognized problems in the Child Welfare Act and child protection system includes all of these. First, parental rights are almost inviolable while child protection agency employees do not have the authority to override the rights of the parents at the scene of abuse. So when there is hotline phone call made reporting of an abuse case, the child protection agency employees are supposed to be at the scene, right? And if the child protection agency employee determines that it is an emergency, child needs to be removed, then they would take certain kind of emergency measure, including separating the child from the parents. However, the child protection agency employees do not have authority to challenge the parental rights of the perpetrator. So even if they want to take the emergency measure, if the parents claim that I'm the one with the parental rights, you cannot challenge that, then they don't have any legal means to challenge this parental rights. Second, also mandated reporting system was not working. So okay, let me ask you a question. How many of you are mandated reporters here? Yes? Can I ask you what you do? Yes.
High school counselor.
Yes. You are a mandated reporter. Yes.
Middle school counselor.
Yes. Okay. Of course. What about you?
High school counselor.
Yeah. Great. And then who else? Okay. Yeah.
Emergency medical.
Oh yes, you're also mandated reporter. So yeah, it's great, but we don't know who didn't raise your hand. But we'll talk about mandated reporters later on. So yeah. So but unluckily at the time, a lot of mandated reporters didn't even know their duty to report, or they were reluctant to make those reports because they are worried about possible consequences. Maybe they might get revenge, you know? They don't know what's going to happen, so there was certain reluctance. Third, also child protection emergencies were supposed to receive help from the police officers at an abuse scene, but often the police didn't even show up. So the role of the police is actually helping the child protection agency employees to get through the situation and then make the parents listen to what the child protection agency employees say. But since there was no police officers, well, poor child protection agency employees, right? And fourth, which is really crucial, services include counseling, therapy, and treatment programs were provided, mainly provided for children, but not really for perpetrators. According to the statistics, services provided to abused children outweigh five times more than the services provided to perpetrators. And given that the child abuse cases are increasing, there are not enough child protection agencies or staffs. And lack of trained professionals, including judges, police, and prosecutors, do not make the problem any better. So, this is the new law. A recognition of the Child Welfare Act's weaknesses led to concerted efforts to improve the child protection for child victims, resulting in the Act on special cases concerning the punishment, etc., of crimes of child abuse. The new law was enacted on January 28, 2014, and it became effective on September 29th, same year. As you can see from the title, the law focuses on strengthening punishment measures on perpetrators. And it takes a quite radical approach because the law assumes that every act of child abuse now constitutes a crime. Okay, so there is no translation of this legislation available on the website. So basically, all the analysis relies on my own interpretation, so certain terms might not be the same if the later translated legislation is available on the website. But I hope that, well, it makes sense to you. And then if you have any questions, please feel free to ask me. So I have laid out the main elements of the new law, and some of these are new, and some of these are not new, but I still included not the laws that is not new because I think that it constitutes a really important part of the child protection system. First, the new law heightens punishment measures for child abuse perpetrators. Like I just said, if the child dies as a result of abuse, then the perpetrators will face life sentence, more than 5 years in prison. And added punishments are applied when perpetrators are repeat offenders or child welfare system employees. And second, the old law did not enforce necessary services on perpetrators. But the new law now includes that perpetrators have to take treatment programs and relevant classes. But that happens after they are charged as a child abuse criminal. And third, it also expanded the duties of mandate reporters. Anyone could report abuse, but there are mandate reporters who have to report, and they include teachers, counselors, and staff involved in working with different welfare facilities, children and working with children in nurseries, kindergartens, public schools, as well as private teaching institutions, which is called 학원 in Korean. Under the old law, mandate reporters had to report when they learned about child abuse and are certain of the child abuse while on their duty. But now, they have to report even if they are just suspicious. If they fail to report, then they will face a financial penalty up to 5 million won. So, mandate reporters, you have to report. Number 4, cooperation between the police and child protection agency employees at the abuse scene. Well, this is not really new, but let me just explain. So because it was not really enforced under the old law, now that the lawmakers emphasize that this function is really important. So actually it has to do a lot. It has a lot to do with the implementation that is happening. Now the cooperation is really working out on the ground. And then number 5, emergency measures. They're also not very new, but CPA employees and the police both can take measures in emergency situations. Emergency measures include, number 1, preventing further abusive conduct. 2, separating the perpetrator from the child. 3, taking the child to the protection shelter. Number 4, taking the child to hospital or to receive medical care. And measures 2 to 4 cannot exceed a period of 72 hours unless the prosecutor requests legal temporary measures later on. So under the old law, the Child Protection Agency employees or the police they took these measures, but they didn't have effective means to limit or suspend the parental rights of perpetrators during this emergency measure period or after the expiration of this emergency period. But now, please look at number 6. With the temporary measures, the police can make a request so that request for temporary measures to the prosecutor, and then the prosecutor will request to the family court to issue a temporary measure. And number 7 is considered a major improvement with the new law, because I already mentioned that the Child Protection Agency employees didn't have enough authority or power to control the abuse situation. But now they have more power with this section of the law. A protection order is issued to limit perpetrators' access to the child and place the child in the child welfare system and medical care or foster care, and limit the parental rights of the parent or guardian. And now the child's representative, and child's attorney and the head of the Child Protection Agency can directly request a protection order from the family court, making timely protection for the child possible. And also, family court judge can directly issue a protection order if the judge thinks that the judge suspects a child abuse case during separate divorce or juvenile proceedings. And the period for protection order cannot exceed 1 year, but can be extended every 3 months. So I made this flow chart just to briefly overview the child protection intervention. So report to CPA, I just call it CPA, but Child Protection Agency or police report is made to Child Protection Agency or police. And the investigation is conducted by both. And the emergency measures for both abusers and child victim can take place within 72 hours. And the police and prosecutor will make a request for temporary measures for perpetrators, which just goes straight down from emergency measures. Or the child's representative or attorney or the head of Child Protection Agency can request protection order from the family court for child victim, which is 1 year up to 4 years. And then also the judge can issue temporary measures if he finds that further temporary measure is necessary for the child victim. Here, the temporary measure for perpetrators is issued, and later on, the prosecutor can ask the family court judge to determine the protection, to make a decision on protection measures, which includes limiting or suspending parental rights and volunteer acts and mandatory parenting class. So now the family court governs the proceeding for perpetrators as well as the child victim. So what's happening on the ground after the law got implemented last September? So reported child abuse cases increased by 30% compared to 2013. And now more training materials are available. I don't know if you have come across any training or educational sessions regarding child abuse, but judges are receiving training based on my interview with the judge. And there have been a lot of forums that invite a lot of different frontline workers, including teachers, counselors, so that they can be informed of the new law. And police actually accompanies the child protection agencies, and that rate increased by 31 folds compared to 2013. And now the family court and child protection agency play much of an active role. So this is almost the final part of my presentation. These are my main comments on the new law and the Korea's current child protection system. So first, I just named it as punishment-centered versus prevention-centered. First, I'd like to comment that the new law heavily emphasized the punishment measures for perpetrators. And the new law is designed as a criminal law legislation. But it lacks detailed prevention measures, which is much more important in my opinion. As I mentioned, the new law takes an assumption that every act of child abuse constitutes a crime and that severe punishment measures will prevent abuse from happening. Yes, punishment measures can warn people, but cannot resolve the root cause of the problem. Studies show that the best way to prevent child abuse is to help parents develop the skills and identify the resources they need to better parent their children. Further prevention requires a continuum of strategies at the individual, relationship, community, and societal levels. The law offers counseling, parenting classes, and necessary services after the parent is charged with a child abuse crime. These services, rather, should be offered early in the stage, considering the economic, social, physical, and psychological circumstances and the needs of the child, parent, and family. Second, although the new law empowered the Child Protection Agency and expanded its role, Child Protection Agency's authority or leadership in the child protection system is still very weak. Part of it can be attributed to the fact that the Child Protection Agency is not a governmental organization, but a civil organization. And the public does not really recognize Child Protection Agency as a strong authority. However, Child Protection Agency employees are the most knowledgeable and trained frontline workers. Their roles in investigating abuse case, working with the child and parent, and providing necessary services need to be supported and further strengthened. Thirdly, compared to the US, where the child protection is led by juvenile court or family court judges, in Korea, the role of the family court is less significant in the early stage of child protection case. Before the case reaches to the court, the police officers and prosecutors make decisions to dismiss, and only those serious cases actually get to the family court. It is hard to tell. I haven't actually made my own conclusion whether it needs to increase the role of family court, but it is important to have child experts, have a specialized department in the family court, and because they still make important decisions for children and perpetrators at the end. And fourthly, the new law now establishes emergency and temporary measures for both the child and perpetrator and laid out who takes what actions in detail. But it does not systematically guide how to come up with long-term or permanency plans for the child when the case is taking a long time and return home, which is reunification, is not a viable option. Fifth, so because I'm a child attorney, children's voices are not really represented in child protection system in South Korea. It is important to protect children's right to participate in the matter that affect their lives and have their voices heard. Child representatives or lawyers, so-called guardian ad litem in the United States, play an important role in child protection proceedings, directly communicating with the children and understanding their needs and wishes, and coming up with recommendations that are in the best interest of the child. Although the child can hire, well in Korea, although the child can hire and be represented by a lawyer at the child's own expense, it is unlikely that the child has the financial means to do so. And 6, the new law needs to be better understood. So another question, how many of you have learned about the new law before you came to this event? Yes? To the 2 of you? That's great. Based on the conversation with teachers and counselors in school and child welfare institutions, I learned that the new law is still mystery to them. More training is definitely necessary. 7th, the lack of budget has been an ongoing issue. The system needs more child protection agencies, employees, and services, but the government does not allocate enough budget for child welfare. In order to strengthen the system, the budget needs to be increased. Almost among all the 34 members of the OECD, the Organization for Economic Cooperation and Development Nations, South Korea is ranked 32nd for the percentage of the government budget spent on child welfare. The bad parenting includes, comparing your child to other children, but just to show that how much money is spent on child welfare in Korea, I just made that comparison. And so here's the end of my presentation, but I want to conclude my presentation with this question. Is it necessary to weaken parental rights in order to increase governmental involvement? Well, before I actually started my project here, that was not even my question. I always thought that the government involvement in child welfare and child abuse cases is definitely necessary, even if it has to weaken the parental rights. But I was thinking, what would be a perfect balance, power balance between the government and parents? Strong parental rights have been indicated as one of the main obstacles that hinder effective government intervention in South Korea. And yes, removal of the child from risk of abuse and sometimes terminating the parental rights of the parents might be a necessary evil. But still other government-designated alternatives, including foster care and institutional care, might not be the ideal place for, might be an ideal option for a child. The most important issue that matters in the end is whether it is in the best interest of the child. So the triangle, at the top of the triangle, it should be a child, neither the government or the parent. Thank you. If you have any questions?
That last graphic was very interesting. Is there anything in Korean law that affirmatively defines the rights of children?
The rights of children, yes. Actually, Child Welfare Act lays out the rights of the child, the rights to protection. I cannot lay out all the details, but yes, Child Welfare Act includes it.
But you mentioned, for example, that a child has the right to hire an attorney to represent herself.
Right.
But what child knows or has the resources to do that?
So that's really not visible. I mean, the law doesn't explicitly says that the child can hire. Well, it says that, it says so, but it doesn't have. Well, the child might be from a really low-income family. Then how can the child hire an attorney? That's a good question. I don't know.
But the state doesn't help them.
So the state actually provides attorneys if the case is recognized as such a serious case that, and then the case has to get to the court, then they will provide state attorneys, the government attorneys. Yes?
So when we were looking at the child abuse law, it seemed very vague in just saying it had to be cruel.
Cruel.
And then we talked, I guess you talked about how
Yes.
corporal punishment is still allowed at home. So
Yes.
where is the line drawn? Because the law we saw didn't seem to really draw.
Right, that's a good question. The line is really not clearly drawn, and that's why there has been a lot of debate going on about where's the line, what's the standard, how can you tell whether it's disciplinary act, corporate punishment, or whether it constitutes an abusive act. We don't know, but according to based on my conversation with one of the prosecutors, he told me that he would consider he would see the purpose of the Parents Act, and he would consider the proper degree of the action, and then third, the proper manner, whether the act actually took place in the proper manner. So they're going to consider several circumstantial factors that, of the abusive act, and they will conclude accordingly. Yes?
What is the burden of proof like? Like, what level of evidence has to be provided for someone to be convicted of child abuse?
Okay, so every child abuse act constitutes a crime. So that's a basic assumption, and burden of proof is not really clear according to the law. It is not mentioned in the new law. So yes, I don't even know. Yes.
Well, let me follow up on that.
Mhm.
If the victim of abuse is a young child,
Mm-hmm.
there's a question is this going to be a reliable witness in court? And
Mhm.
I could think of an aggressive defense lawyer
Mm-hmm.
cross-examining a 5-year-old
Exactly.
and showing, oh, well, the 5-year-old thinks that people can fly if they want to, and
Right.
so therefore this testimony that
Yes.
the 5-year-old was sexually assaulted by a stepfather
Yes.
doesn't count for anything. So is there any any measure somehow to
Measures?
protect child witnesses from fierce cross-examination?
Exactly. That's a good question. So I read a news article which talked about the exact situation that you just described. A child was supposed to testify in the courtroom, and the judge didn't even know how to properly address the question to a 5-year-old child who might not be able to even understand the question properly, right? So I think that they actually read some guideline and books that were published in the United States, and they brought a social worker who has been working with the child and try to make the situation as a conversational forum rather than adversary court proceeding. So that, and then the judge was not even wearing a robe at the time, so that she can actually talk to as if she's an auntie or someone who's much more familiar. So I think that they're trying to make those kind of efforts and changes in the courtroom as well, considering the child's intellectual, limitations and age, etc. Yes?
In South Korea, there's some interesting liability for people who charge someone or file a lawsuit against someone. You can, if it's shown that you're not accurate, then you're open to some lawsuits against you for defamation.
Defamation.
Mandatory reporters.
Mm-hmm.
Is there any protection or support for them if they report child abuse that's then determined by the court and the authorities that it's not child abuse against defamation lawsuits or other things that might, make them less likely to?
So you're asking whether there is protection for mandate reporters when they report, but the case turns out to be not an abuse case. Well, so they are now supposed to report the case even if they just suspect. So it doesn't have to be, they don't have to be certain, but they have to have certain kind of suspicion. So that the bar is very low. They can easily, say why they got really suspicious, right? So I don't think that even if the case turns out to be not an abuse case, they'll still be protected, right? Yes?
I think Thank you so much for your presentation. I have a question about one of your earlier graphs. The one that shows the increase in reported cases versus convicted cases.
Yes.
And so you were talking about how the new law kind of emphasizes punishment of perpetrators.
Yes.
But it looks as if the gap between proven cases and like increase or just reported cases versus convicted cases is growing bigger. And I was wondering if you can explain that discrepancy, if I'm reading the graph correctly.
Yes, I think that now people are became more suspicious about child abuse. So they're more vigilant, they're more aware, so that if they just see something that's similar that might grab their attention, they will immediately report. So that might not actually necessarily be an abuse case according to the Child Protection Agency standards. So I don't know whether that answers your question, but they can be one factor. Yes. Yes?
Do you happen to know if the law covers all children residing in Korea regardless of nationality?
Yes, that's true. Actually, I knew that some of you might be coming from international schools, so I had to make a phone call to the Child Protection Agency, and she said yes. Nationality doesn't matter. If you're a child living in South Korea, then you are protected under this law. Yes.
So, speaking of international schools, are there, I mean, we have obviously everyone in our school that would be a mandated reporter. Are there, and yet very few must be Korean. If you're going to make a report, is there a way to do that in English, or how do people navigate that?
Well, that's a good question. Now you can directly call 112, which is the direct police phone call line. And I wonder whether they have translators. But if you speak English, I'm sure they'll know that they need a translator. Well, let me actually ask that, and then we'll get back to you if you give me your business card. So yeah. More questions? Yes, Stephanie?
So there's currently a case going on in the U.S. It's about a Korean woman leaving the U.S. and had a child with an American citizen, and then she ended up leaving and then coming back. And what happened is, like, he charged her with child abduction, and so she's currently facing like deportation on visa for the child. But community activists are saying that she fled because of like a domestic violence problem, and so the reason she left was like for safety for herself and the child. So they argue that actually, like, what's happening is like the child welfare system is being used to like perpetuate like domestic violence and possibly like towards child abuse if he like is like guardian of the child. And so I was wondering like what's the relationship between domestic violence and child welfare in Korea, like with the system?
Sure. That's such an interesting case. I heard about it, but I didn't get a chance to actually go deep into the case. But yeah, domestic violence and child abuse can happen coincidentally. I mean, not coincidentally, no, at the same time, but simultaneously. Because if the perpetrators abuse his child, there is no guarantee that the perpetrator doesn't abuse his wife or anyone in the family, right? So actually, it is interesting because the new law was modeled after the same criminal law proceeding for domestic violence. So before this new law was created, the prosecutors and police officers were following the procedures under the domestic violence law. So the children wouldn't be separately considered in the case, but they would be considered same as their father or mother who are also victims. So I don't know. I mean, they are really close in the nature because there is violence in family, and it's whether the child becomes a victim or the adult becomes a victim, right? But now that there is a separate legislation for children, the court is now going to look at the two separate legislation that is for domestic violence and child abuse. Any other questions? Yeah? Great, we didn't exceed 1 hour. Great.